Hello and welcome to this talk on the public access scheme and appeals. This is the third talk, and we're looking at ways in which you can understand the appeals system so that you can instruct your barrister under the public access scheme more easily and more cost effectively. I want to look now at the contents of your notice of appeal. One thing is that the notice of appeal must be on a particular form. It's called form N161, or if you have a small claim you use form N164. Now, both of these you can download from the court's website. What the notice has to do is contain the basis for your appeal. This is the grounds for your appeal, or the reasons for your appeal. I'd really recommend that you give careful thought to these grounds, or better, obtain advice before filling out the form. There's space for your reasons at section 7 of the form. What you have to do is set out clearly why you say the decision of the lower court is wrong, or that the decision of the lower court is unjust because of a serious procedural or other irregularity. And I suggest you have a look at CPR 11.3. Always set out the document in numbered paragraphs, and I'd recommend you use sequential numbering in the sense of 1, 2, 3, 4, etc., rather than have numbered paragraphs and subparagraphs. So 1, 2, 3, 4 is better than 1, 1.1, 1.2, etc. The latter type of numbering can be very confusing for a judge, and it also takes up more space on the page and gives for more opportunity for error. I suggest that you give a heading to each separate reason for your appeal. Now, this helps you to think more clearly about what are the separate reasons and why they're distinct from one another. But it also means that you can flag up the general areas that you want the judge to look at. What you need to do is to have a paragraph under each heading of this sort explaining why you think that the ground raised, or the reasons that you're giving, raises an appeal on a point of law. We're going to look at what's meant by that in a minute. If it's an appeal against a finding of fact, then you need to make clear why you think it raises a sufficient ground for that. The contents of your notice of appeal are very important, and unless for whatever reason you can't do it, I would really urge you to instruct a lawyer to assist you with them if you're able to. There are, if you cannot afford to pay for a lawyer, bodies who can assist you, such as the Bar Pro Bono Unit, and you can find those by doing an internet search for the Bar Pro Bono Unit. So, what is a point of law? Well, I think the first thing to say is that many people who want to appeal, in fact want to appeal on the basis that the judge didn't find in their favour, and the judge didn't find in their favour because the judge believed the other side on questions which are just plain fact. Sometimes people worry about whether inferences which the judge has drawn from facts are factual, or whether they get promoted to the status of being points of law. Well, they're capable of being themselves findings of fact. If the judgment's got anything in it which is obviously bad law and is relevant to the outcome, then clearly the judgment's erroneous in law, and that will provide you with at least the initial basis for an appeal. On the other hand, it may also be that the facts which are found give rise to a ground of appeal, but it's only in very limited circumstances that this occurs. And I'm just about to talk about some of those limited circumstances. What you need to do, however, is look at how difficult to satisfy the test is when you want to appeal on the basis that a judge has apparently applied the right law but made a complete mess of the facts. Now, what you have to be able to show is that the facts found are such that no person acting judicially and properly instructed on the relevant law could have reached the conclusion that the judge did. If you can do that, then you've got a point of law. The court has to intervene, and if you can prove that, it is forced to assume that there's some misconception of law that's been responsible for the conclusion, which is one which no person acting judicially could have reached. So, if there's no evidence to support the determination, or if the evidence is inconsistent with and contradictory of the determination, then you may have this type of point of law. Or if it's a situation in which the true and only reasonable conclusion contradicts the conclusion actually reached, then again you may have that type of point of law. But I would suggest that you're very careful and honest with yourself in trying to work out whether or not you've got that kind of point of law. Because no person who has lost a case where the judge doesn't agree with them on the facts will think favourably of the conclusion reached by the judge. You've got to be able to prove more than simply the judge didn't agree with you and they should have done. A far more straightforward type of point of law is what a statute means or what a contract means. It's a question of law what meaning is to be given to the words of a statute, or indeed the words of a contract. It's for the court to interpret its meaning, having regard to the context in which it occurs and to the principles which the court uses to interpret or work out the meaning of those sorts of terms. So if your point of law is in those sorts of terms, that the words of the statute or the contract have a particular meaning and therefore the conclusion should have followed in your favour, then it's worth thinking about bringing an appeal against the decision if it doesn't share that view of the meaning of the law. There are some things to be said for writing your own notice of appeal. First of all, it's cheaper and you'll certainly say what you want to say. But I think there are many more negative things that one can say about this. The first danger is that you don't identify the points of law that you need. But there's an equal danger that by trying to say everything that you think possibly could be said, you bury the points of law that you need to establish and which may be valid amidst irrelevant complaints. And this is something that I have repeatedly seen when people have done their own notices of appeal. And it's important in those circumstances to go over the notice of appeal and to sift out the good points that can be argued. But judges won't necessarily have the time or resources to do that. So the risk of burying your good points under irrelevant points is one which you should guard against. So you have to apply your judgment to identifying the points of law that you need, and only the points of law that you need. Now, it may be that you start your appeal by doing your own notice of appeal, and then later on you have to bring in a lawyer to look at it, or later on you realise that there are other points that you could have been making. Well, altering the basis of your appeal may have cost implications, and we'll talk about amendments later on. Looking further at this concept of there having to be an error of law, you've got to show that the lower decision maker misdirected themselves on the law, misapplied the law, or misunderstood the law applicable to the proceedings before it. The way in which the tribunal or court approach the facts amounts to an error of law if there's no evidence to support a particular finding of fact, if the decision was perverse, as we've just been looking at, or if it exercised its discretion wrongly. There are two other types of error of law to look at, though. One is the failure of the judge or tribunal to give adequate reasons for its decisions, and then finally breaching the rules of natural justice or human rights. So, for example, if there's an excessive delay in giving judgment. Let's look at misdirecting itself on law. This can take the form of failing to ask the correct legal question. Now, if you're going to assert that, you'll have to be able to assert what the correct legal question actually is, and give some thought to how you formulate that. You may need, for example, to refer to the words of the statute, or you may need to refer to case law of which you're aware. Secondly, misdirecting itself on law can include misconstruing a statute or contract, as we've just discussed. Or it may be that it's failed to follow a case which sets a relevant principle of law, and which was decided by a court which is higher in the hierarchy of courts in our legal system. The point there is that lower courts are obliged to apply relevant principles of law which are set by the higher courts. So that might be a higher tribunal, the Court of Appeal, the Supreme Court, or if you've got a European Union law at the heart of the case, then the cases of the Court of Justice of the European Union are going to be relevant. Now, misdirecting on points of law frequently involves looking at difficult points of interpretation of the law or statute or human rights. If you're going to take your appeal yourself, then you do need to be prepared to spend the time researching the points of interpretation of the law or statute or the questions of human rights that are involved. And there are a number of websites that can give you materials and which are free to access, but you do need to exercise caution in using these. I mentioned earlier the erroneous approach to the facts, and I make the point again that it's not a ground of appeal to say that the lower tribunal disagreed with your evidence. However, there being no evidence whatsoever to support a finding of fact is a ground of appeal, and sometimes you can argue successfully that because there's such insufficient evidence, the finding was perverse. If you can establish perversity, then that's an error of law, but the test for perversity is very high indeed. So it's a decision that no reasonable court or tribunal properly directing itself on the law could possibly have reached. What you need to ask yourself is whether you can really say that the decision is in such a way irrational, or offends reason, or is certainly wrong, or is very clearly wrong, or any of those other phrases that are up on the screen. But I would ask you, when you're considering whether or not you've really got a point of this nature, to take a step back. You may well feel that all of these ways of thinking about the decision that's gone against you is absolutely right. Because what we tend to do is to put the reasonable person as someone who has all of our characteristics. But that's actually not what this test means. And the difficult step that you have to take, and again I'm afraid it's another reason why it's worth consulting a lawyer, is whether looked at objectively, so without the emotion and involvement that you have in your own case, it's possible to say that the decision is irrational, in the sense that no reasonable decision maker could possibly have reached it. So if you are in a situation where you can see that a decision maker might have found, as the decision maker has on these facts, then it may well be that you need to think again about whether to include this ground of appeal. The court will only interfere with the finding if it is persuaded that all of those epithets, or a combination of the sense of those epithets, can be applied to the decision. And it is very, very difficult to persuade the appeal court that a decision is perverse in this sense. And there's a good reason for this. We delegate to the first level of decision making the function of determining what the facts are. That's their job. They hear the evidence and they see how people give their evidence. They are there on the spot making those decisions about credibility, importantly. The appeal court's job is different. It isn't to rehear the case in most cases. It's to decide whether or not something went wrong with the process of decision making. So it's not going to get involved, even when it feels that if it had been hearing the case itself, it would have reached a different conclusion on the facts. What it has to be able to say is that the decision is one which no reasonable decision maker could have reached. And this leads to a rather chilly atmosphere if you're trying to bring an appeal which is based on perversity. The courts take the view that they should only succeed where there's an overwhelming case made out. So, if you're going to go along this route, you need to prepare very carefully for a perversity appeal of this nature. One of the ways in which you can do this is to set out in the notice of appeal, or your grounds, a table showing how the court or tribunal either did take account of an irrelevant factor or failed to take an account of a demonstrably relevant factor, and to set out the matrix on the basis of which you say that there was only one conclusion that a rational decision maker could reach. This question of taking account of factors also is a way of attacking the exercise of discretion. You can appeal against the exercise of discretion if the decision maker took an improper or irrelevant factor into account, or failed to take a proper or relevant factor into account. And then finally, discretion can be challenged where it is perverse. I mentioned earlier the basis for appeal, which involves the insufficiency of reasons. here's the test and here's the caution. A decision must contain sufficient reasons so the parties know why one has lost and the other has won. There is a common law duty to provide reasons, but there's also a right to a fair hearing under Article 6 of the European Convention on Human Rights and Fundamental Freedoms. Both of them require proper reasons to be given for a decision or order. However, the appeal courts can ask the judge or tribunal that made the decision to provide additional reasons for the decision, or the reasons for a specific finding or set of findings. And they're increasingly likely to do that rather than determine the appeal on the basis of insufficiency of reasons, because that's far preferable to expensive appeal proceedings on the grounds of a lack of reasons. So it is always worth finding out whether you can obtain the reasons from the court. The judge, however, does have to make findings. If the judge is faced with the decision whether a particular event occurred or not, and if that's necessary for the decision, then the judge's got to find as a fact whether or not it occurred. Notice that the evidence may go either way, and in which case the court or tribunal is entitled to decide one way or the other. If there were ever a situation in which the evidence is so evenly balanced that it can't make up its mind if the event occurred or not, then resort is made to the concept of the burden of proof. The court or tribunal that decides a fact or a series of facts on that basis should explain that it's relied on where the burden of proof lies and make a finding accordingly. So what that means is if you're the claimant and you've asserted something, or indeed if you're the defendant and you've asserted something, then the burden of proof is likely to be on you to show that that something has occurred. Some indications that the judge has failed to engage in the proper decision-making process include formulas such as I cannot make a finding that, or we're unable to find that X, Y or Z. The problem is, you see, that if the court or tribunal doesn't make decisive findings, the parties may not know why they've won or lost, and they're entitled to know that. The court or tribunal must hear both parties. These are the principles of natural justice. It must avoid procedural irregularities. So this includes matters which it thinks up after the hearing and doesn't put to you to deal with. It mustn't be biased. Now, bias is a really difficult ground to establish. I'd strongly recommend that if you think that there may have been bias, you should seek advice from a lawyer early before alleging that it's occurred. This isn't because it's a taboo to suggest that a decision-making tribunal has been biased. It's just very difficult to establish. And I would suggest that if you do make an allegation of bias in your notice of appeal, you really need to give full details of every complaint of bias that you're concerned with. And in order to help you to do that, or not, you need to consider the correct test. What you have to ask is whether a fair-minded and informed observer, so that's somebody who doesn't just read headlines but reads down the page, goes into a bit of depth, so would a fair-minded and informed observer, having considered the facts, reach the conclusion that there was a real possibility, as opposed to a fanciful one, that the court or tribunal was biased? So the mere fact that in a previous case or earlier in the same case that there were adverse comments made by that same judge about you or a witness, or if the judge found your evidence to be unreliable, that wouldn't, without more, give rise to a sustainable objection of bias. So you can't assume or expect that findings which were adverse to you in one case are going to entitle you to a different judge or tribunal in the later case. You've got to be able to show more than that. So what do we mean by a real danger or real possibility, however you phrase it, of bias? Well, there's some pretty clear examples. If there's a personal friendship or animosity between the court or tribunal and any member of the public who's involved in the case, a close acquaintance with a member of the public who's involved, particularly if that individual's credibility may be significant. Suppose the court or tribunal had to decide on credibility and it had rejected the evidence of the person in a previous case. Well, I've said it's not enough. The something more may be the warmth or how outspoken the rejection of credibility was. In some cases, if the judge has so radically rejected the person's credibility in outspoken terms, it will cast doubt on the court or tribunal's ability subsequently to approach that same person's evidence with an open mind. But that's really the test that you need to look at. How outspoken was the rejection of credibility? Can it realistically be said that there's therefore doubt as to whether the judge approaches the new case with an open mind? Similarly, if a judge or tribunal expresses views on any question which comes up in proceedings, and particularly some that come up in the course of the hearing, so if the judge makes remarks which are in such extreme and unbalanced terms as to cast doubt on that tribunal's or judge's ability to try the very same issue objectively, then there may be a real danger of bias. And finally, if there are real grounds for doubting the ability to ignore extraneous considerations, prejudices and predilections, and to bring an objective judgment to bear on the issues in the case, then you can assert a real danger of bias. But what you've got to be able to do is to show in detail what the reasons are for doubting the judge's ability. It's got to be more than just the fanciful suggestion or the suggestion which is born out of general assumptions made about the particular type of judge or what you think of as their social class, etc. There's got to be some detail which would, to an outsider, demonstrate why this person might not bring an objective mind to bear on the issues.